This is the second video in a series that I am doing about Julie's bill, the legislation that myself and many others are working to have passed here in Wisconsin. And what it is the federal legislation that was passed this year in the Violence Against Women Act included keeping children safe from family violence, also known as Caden's Law. And we are seeking to have that legislation passed here in Wisconsin. Essentially, what this bill would do would be to expand on the legislation passed by Wisconsin in 2003, Act 130, which provided protections for victims of domestic abuse in custody cases in Wisconsin. And in this video, what I'd like to cover is the federal findings that were published in the federal legislation in the Violence Against Women Act and why it is important to continue to expand legislation and these federal findings for why we need to be working to keep children safe from family violence. And the first of the findings that was published in the federal legislation states that approximately 1 in 15 children each year are exposed to domestic violence. And so it's really important that we understand how prevalent this issue is. And when the individuals that have worked on the federal legislation in keeping children safe from family violence have spoken about the importance of the legislation not just being about laws, but about culture change, that we really need to change the cultural approach to domestic abuse, child abuse, family violence, things like incorporating what we've learned in the advancement of psychology with things like understanding the ACE scores and the implications of the psychological and health impacts on children, and understanding more about the impacts of the court system itself and things like the Saunders study and Joan Meyer's study about gender bias in courts. So as we've learned and advanced in our research and understanding of these issues, it's important that we continue to have cultural shifts in how we are approaching this, and understanding that 1 in 15 children are exposed each year to domestic violence is important, that we're no longer approaching this as just a family issue or private, that it's kept behind closed doors, that we really need to understand the prevalence and the impact, and that we can start to do something about it and seek to see change, to take away even some of maybe the shame that keeps the silence around this, because typically we see a lot of generational factors in domestic violence and domestic abuse, and at some point we really need to just be able to talk about this issue and stop the cycle, and to really seek to help and to seek to see healthy individuals, healthy families, and healthy communities. The second finding is that most child abuse is perpetrated in the family unit. So intimate partner violence and child abuse overlap in the same families at a rate of 30 to 60%. So a child's risk of abuse increases after a perpetrator of intimate partner violence separates from the domestic partner, even when the perpetrator had not previously directly abused the child. And this is critical that we are talking about this and that we understand that there are grave risks when a victim leaves domestic abuse. And the post-separation abuse that happens is extremely dangerous and has extremely negative impacts on the victim and the children. And we need to understand that this is a serious safety concern as the victims leave the situation. So it's not just about this cultural idea we have that, why don't you just leave? As if you leave and then you're not in a toxic or dangerous situation. In fact, when you leave, you're in sometimes worst position and in some of the worst positions you will be in as a victim of domestic abuse when you do leave. And we need to have more clarity in communicating that effectively so that as individuals, as loved ones, as community members, and as policymakers, that we can be understanding that we need to relook at how we are approaching the danger of leaving domestic abuse and really looking to stop the harm that it causes in post-separation abuse. Children who have witnessed intimate partner violence are approximately 4 times more likely to experience direct child maltreatment than children who have not witnessed intimate partner violence. So there are serious impacts on children that are in homes where there is a perpetrator of domestic abuse. That is part of why we passed the legislation here in Wisconsin in 2003. We have seen End Abuse Wisconsin put out studies with the Wisconsin Bar about the concerns that the policy and the legislative reform that has been passed and put in place is not really taking effect in the courts, and working hard to see how we can come around and support this legislation, Julie's bill, in incorporating these federal findings and the federal bill that will be in subsequent videos diving deeper into what the wraparound legislation is seeking to do, and it's to continue to address this issue. The third finding is that more than 75% of child sexual abuse is perpetrated by a family member or a person that's known to the child. And the U.S. Department of Justice data shows that family members are almost half the perpetrators of child sexual assault victims under the age of 6. Again, it's important that we are understanding that this isn't just a family issue or keep behind closed doors, that these are topics that we don't want to think about. We don't want to think about that they're happening, but the statistics show us that it is happening. It is a societal problem. It is something that we have to be more courageous about talking about and addressing so that we can see a more healthy approach to helping the perpetrators figure out how we can stop this behavior and being able to support the victims, and that we can see an end to the continued cycle of this kind of behavior. The fourth finding states that research suggests that a child's exposure to a batterer is among the strongest indicator of the risk for incest victimization. One study found that female children whose fathers were batterers of the mother were 6.5 times more likely to experience father-daughter incest than female children who do not have an abusive father. So understanding these statistics are really important, and realizing that when there is a perpetrator of abuse in the home, we really need to be looking at all of the implications of the risk factors that this imposes on the family and the victims. The fifth finding is that child abuse is a major public health issue in the United States. A public health issue. Total lifetime financial costs associated with just 1 year of confirmed cases of child maltreatment, including child physical abuse, sexual abuse, psychological abuse, and neglect, results in $124 billion in annual cost to the United States economy, which is approximately 1% of the gross domestic product. So when we look at addressing the issue of domestic abuse, we are motivated by the moral imperative, right? The moral imperative to protect victims, the moral imperative to see this kind of behavior stop. Beyond that, and in relation to that, we also have to understand that this has a cost. Doing nothing costs us. The issue itself is costing us. Not only is it costing the individuals their own suffering and their own health implications, and not only to the community, is it impacting community when you think of the budgets passed by individual counties and the state and the individual states for the entire country. This issue has a cost, and we need to understand that we need to be looking at how we can make positive change, and that doing nothing is not an option, and that's part of what Julie's bill is seeking to do in adding further legislation around addressing the issue of keeping children safe from family violence. The sixth finding that was included in the federal legislation states that empirical research indicates that allegations of child physical and sexual abuse are regularly discounted by courts when raised in child custody cases, with fewer than 1/4 of claims that a father has committed child physical or sexual abuse believed. And where the allegedly abusive parent claims the mother was alienating the child, only 1 out of 51 claims of sexual molestation by a father were believed. However, independent research indicates that child sexual abuse allegations are credible 50 to 70% of the time. So this is really important for us to understand that there is an issue in custody courts, and we have to take the keeping children safe from family violence legislation seriously. We need to be discussing these empirical research findings, this federal legislation findings, and we need to be implementing it here into Wisconsin law to build on what we passed here in Wisconsin in 2003 in Act 130, so that we can continue to address why this is happening and to create a safer community, to create legislation that actually keeps children safe from family violence. We know that this is happening. We have the statistics, we have the research, and we need to be able to speak about it so that we can address common sense reforms, protection for the children, legislation. The seventh finding in the federal legislation states that empirical research also shows that alleged or known abusive parents are often granted custody or unprotected parenting time by the courts. And of course, I need to stop and make a statement about the fact that that is what my case, the Valadez case, has set case law here in Wisconsin. Here in Wisconsin, we have a state that passed the 2003 Act 130 legislation. Here in Wisconsin, we have a state that brought together the experts that we do have on this subject here in Wisconsin, and they work together to write a guidebook for the courts on domestic abuse. And yet, you have the Valadez case here in Wisconsin that had a finding of a pattern of domestic abuse by Mr. Valadez, and yet defied the law, knowing the law, defied it, and gave sole custody to the abuser with enough finding that Miss Valadez, myself, was a fit parent. And that's what this empirical research and this federal legislation is educating the public, that when there is alleged or known abusive parents, they are often granted custody or unprotected parenting time. And in fact, in my case as well, my ex and I had stipulated to the law and what is obviously required in our case, that I had sole custody. I'm also the primary caretaker and the stay-at-home mother, and we had stipulated to his supervised visits. It was the court itself had took it away with no findings warranting taking the supervision away. And it goes on to say that approximately 1/3 of parents alleged to have committed child abuse took primary custody from the protective parents, reporting the abuse, placing the children in ongoing risk. And of course, I'm very passionate about this finding because we're watching it play out here in Wisconsin. All of the public, the community, the legislature, the bar, everyone, or the majority for sure, is familiar with this case and that it's happening here. And that to date, myself and my children are still subjected to unlawful orders. Again, despite myself and my ex entering a stipulation that complies with the law, the court itself has violated it. And to this day, since 2018 to now 2022, at this juncture, we still are subjected to unlawful orders. The eighth finding is that researchers have documented nearly 800 children murders in the United States since 2008 by a divorcing or separating parent. More than 100 of these children murders are known to have occurred after a court ordered the child into contact with the dangerous parent over the objection of a safe parent or caregiver. We really need to listen to this research, listen to the experts here in Wisconsin, listen to the mothers across the United States, that at this point it has reached a crisis of murdered children that never had to be, that they are being court ordered into abusive situations. That is why we need legislation to further provide the protection to keep children safe from family violence. Our system is failing. The ninth finding is that scientifically unsound theories that treat mother's abuse allegations as likely false, attempts to undermine the father, are frequently applied in family court to minimize or deny the parents' and the child's actual reports of abuse. And in fact, this isn't in the finding, but we certainly see, in my case and in many cases, that we're seeing this despite the actual evidence of abuse, or in my case, an actual finding of domestic abuse by the court. They're still making some unsound theory of an assumption that somehow is an alienation that somehow minimizes the actual abuse. Many experts who testify against the abuse allegations lack experience in the relevant type of alleged abuse, relying instead on unsound and unproven theories. And I have to say, Molly Jasmer is certainly an example of how this is incredibly dangerous to the public interest, to have someone act as she is here in Wisconsin. And it's why we need to also have a GAL oversight body here in Wisconsin, which is something we are also working on, so that we can have some accountability and oversight when individuals that are not qualified or are presenting unsound theories or scientific hypothesis surrounding some sort of an alienation. And again, this is specifically using the term when there is an abuser to minimize the abuse. So it's when they know that there's abuse, and then they say, well, somehow protecting the children is alienating, and then that somehow minimizes in court. And I know there's a lot of confusion around that word, but hopefully that helps to give you some context around exactly what this finding is regarding And you can see an example of it specifically by reading the transcripts in my case, by learning about the Valadez case and the case law that it's setting, and learning more about the conduct of Molly Jasmer. It's an example of why we need an oversight body and why we need more legislation to regulate a guardian ad litem. And then the 10th finding is that judges presiding over custody cases with allegations of abuse, child sexual abuse, domestic violence, they are rarely required to receive training on these subjects, nor have most states established standards for such training. And that's why we're working on having standards both for guardian ad litems, for custody evaluators, and this is an expansion on the 2003 Act 130 here in Wisconsin that did important legislative work to require investigation into domestic abuse in cases in custody courts. But we currently have no standard. We have no standard, we have no oversight, and we need to expand on this so that it's effective, because as the 2018 study here in Wisconsin by End Abuse Wisconsin that came out in the Wisconsin Bar in the family law section stated that the research here in Wisconsin is showing that the 2003 Act 130 is not having an effect in the courts. It's not being implemented. And so this federal legislation that we're looking to enact here in Wisconsin in keeping children safe from family violence, or Julie's bill, is what we need to actually see the implementation and actually see the standards given. And this is also something we are working with to have petitions for Supreme Court rules as well as legislative bills passed. And it's important to understand that currently in Wisconsin, there is no requirement for judges to have any training on domestic violence. And that's something we're working right now to see change at Wisconsin Women for Change, myself, and other survivor advocates. And that is why we're working on Julie's bill. So I hope you continue to follow and listen to the series. I will be going more into the specifics of the legislation in the next video, and appreciate you taking time to educate yourself on this important issue, keeping children safe from family violence.